Lovely, we'll get started. Well, kia ora koutou katoa, no mai haere mai, and welcome to workshop one of two on preparing for New Zealand's modern slavery legislation. My name is Jay, and I have the pleasure of working for the Sustainable Business Council. This workshop's delivered by Chapman Tripp as part of the Deloitte SBC Walk Free Collaborative Advantage Program. We should probably make that into some sort of acronym, I imagine. It's such a moment to be having this corridor. As many of you probably know, New Zealand's modern slavery bill had the first reading yesterday. And so this is an excellent opportunity for you to understand not just what's coming, but how you can be engaged in shaping that process. And I love a bit of shameless plagiarism, so I blatantly ripped this off the lovely Becky Kingy's LinkedIn post saying we'd be joined by an incredible group of specialists committed to lifting the bar on responsible business in Aotearoa and supporting entities with the incoming regime. Couldn't have said it better than myself, Becky, so thank you for those words. Here. I thought I'd talk briefly through what to expect for this session. So the session is recorded, so no swearing or we'll have to edit you out. We'll be covering how we got here, a closer look at the modern slavery bill itself, a slightly deeper dive into what needs to be in your modern slavery statement, and also a case study by Francis at KMD Brands. I encourage you to post questions and Q&A throughout. There will be a time for questions at the end. I think you can also vote up the ones that you want answered, which will help us prioritize though. When we were designing the series, we were keen to find the balance between recognizing that this is going to become likely a mandatory requirement for a lot of businesses, but recognizing this is also about the well-being and the rights of the people in our workplaces and the people in our supply chains. So let's keep that front and center of our thinking today. As Becky already articulated, we have a phenomenal lineup of speakers, from an enrolled barrister and solicitor of the High Court of New Zealand to someone recognised as the Fast 40 Rising Stars in ESG in 2025 to the ex-leader of the New Zealand Policy Research Institute at AUT. I will let you guess who is who. Speaking of which, it's my pleasure to introduce our first speaker, who did used to head up the New Zealand Policy Research Institute. So that is one clue for you, and is now the Equal Opportunities Commissioner, Equal Employment Opportunities Commissioner at the Human Rights Commission, Professor Gail Pacheco. I've noted also you have a life membership of the New Zealand Association of Economists, which I would like to know if it comes with a badge or a trophy or a secret handshake. Maybe you can cover that in your conversation this morning. Welcome, Gail.
Thank you so much. Happy to cover that. It comes with free attendance to the New Zealand Association of Economists annual conference for the rest of my life. So it's quite a financial liability for the association to have given it to me at this age. Thank you for that introduction, and hopefully everyone can see my slides. Yes, great. So what I'm going to present today is the human rights perspective on this, and I've just got 10 minutes, and then I'll pass to the real experts on modern slavery in this space, who will give you a lot more detail. So mine will be quite high level. And I thought what I'd start with, very basic. No, I can't click. Oh, there we go. Is the role of the Human Rights Commission and what our role is more generally, kind of the high level business and human rights principles to think about. So I really like that Jay said, this is, important to keep front of mind in addition to kind of what's the kind of regulatory requirements. Then I'll touch on modern slavery legislation in other jurisdictions, as well as the trajectory of those, because I think that's useful to think about, not just what is coming in New Zealand, but what could be the trajectory in the future as well. And then our proposed modern slavery law, which had its first reading yesterday. So a little bit about the Human Rights Commission. The role of the Human Rights Commission is to promote and protect human rights in New Zealand through education, advocacy, monitoring, public engagement, and this includes resolving discrimination complaints through mediation and inquiries, advising government, advising public on a number of human rights issues. And we also engage internationally with quite a large range of United Nations human rights instruments and mechanisms. For instance, the Convention on the Elimination of All Forms of Discrimination Against Women, Convention on Elimination of Racial Discrimination, etc. So that's also a big part of our work. In terms of the role of the EEO Commissioner, myself, we've tasked with leading discussions on priority areas. And these priority areas, of course, include equal employment opportunities, but the range of things we work on in this space include migrant exploitation, gender and ethnic pay gaps, pay equity, as you can imagine, is a big area, diversity, equity, and inclusion, and modern slavery, and business and human rights. So that gives you just a flavor of the things that cover the role of Equal Employment Opportunities Commissioner. Gender-based violence as well, I should have added. So let me touch through kind of at the high level, business and human rights. So business and human rights is the responsibility, and I know this is probably telling a lot of you to suck eggs, and many of you will know this, but I've just kind of written this presentation in a way that assumes you don't have much knowledge in this space. So, for those who do know this, please bear with me, and we'll get to more interesting things later on. So it's the responsibility of companies to respect the human rights of everyone affected by their operations and their supply chains. And it recognizes the influence companies have over working people's lives. So this includes, working conditions, wages, hours, health, safety, discrimination and harassment processes, etc. And it also recognizes that companies have that influence over how they shape the power imbalance, and of course over supply chain decisions that they make. It's grounded in international human rights standards, including the UN Guiding Principles on Business and Human Rights, or UNGPs, and that was endorsed by the United Nations Human Rights Council in 2011, so 15 years ago. In terms of the UNGPs, these were, they're often referred to as the Ruggie Principles, developed by John Ruggie, and it's a global standard for preventing and addressing business-related human rights harm. And it's got 3 pillars to it. So the first pillar is the state duty to protect human rights. The second is the corporate responsibility to respect human rights. And then the third is to have that access to remedy. So while it's important to point out here that this isn't a treaty and it's generally not binding law, they provide really this useful global baseline, right? And it's a very practical framework in which policymakers can use it in writing legislation, courts can use it as well, companies use it, and NGOs and trade unions make use of it regularly as well in advocating. So now if I go on to what's happening in terms of modern slavery at a broad level overseas, in the EU, they've got a very broad regulatory framework there. So I think it's best to describe it as sort of a growing package of laws that are aimed at preventing forced labor, human trafficking, child labor, and labor exploitation in supply chains. And it got sort of 2 pillars to it. The first one is around corporate sustainability due diligence. So that requires large companies to undertake due diligence. So they've got to effectively identify, address, prevent, mitigate, and remedy, any negative human rights risks that are associated with their operation. So that's the first pillar, due diligence. The kind of second area, which is coming in and will be applicable from the end of next year, is forced labor regulation. And this one is around import bans. So it means that it's more of a trade enforcement tool. So it's focused on the product, not just the company. So this is going to involve banning products that are produced using forced labor, products that are being exported using forced labor, products that are being sold within the EU market using forced labor. So this is quite the direction that is going for modern slavery in the EU. Now, in terms of what it looks like in the United Kingdom, here it focuses primarily on reporting requirements, which means large employers must publish a statement explaining the steps they've taken to address modern slavery in their operation. And this requirement to report is, it doesn't oblige the company to take really specific steps. It's a transparency measure. So it's not the same as the due diligence that we see in the EU. They have established an anti-slavery commissioner, and the role includes, promoting best practice, improving victim identification. And in a 2024 Parliamentary Committee report, they recommended moving from reporting onto due diligence as well. And in Australia, they've also got the focus on reporting requirements. So this is for employers who have 100 million plus in revenue. So they've got to take steps to address modern slavery through reporting. Like the UK, they don't have due diligence. They have an anti-slavery commissioner at the federal level. They also have a New South Wales anti-slavery commissioner. And in their 2024 review, they recommended moving from reporting to due diligence as well and expanding the commissioner's power to make high-risk declarations for certain locations, industries, or products as well. So you can see for both the UK and Australia where they've started in terms of their reporting requirements and the trajectory they're heading towards in terms of due diligence. So I'll end with where we're at in New Zealand before I pass on to the real expert in this space. So in New Zealand, just to remind everyone, modern slavery is about the exploitation of people both in New Zealand as well as people overseas within the supply chains for our New Zealand companies. So within New Zealand, this is including people who are forced to work against their will, trapped in jobs through debt, or coerced or deceived into exploitation. Now, we know that modern slavery affects millions of people globally, and it's estimated by organizations that it also affects 8,000 people within New Zealand who experience different forms of modern slavery. So where are we at? Well, we've got a proposed law that had its first reading yesterday. It started in a bipartisan bill being announced earlier this year, which was co-sponsored by both National and Labour, and actually started years ago. And I don't know if Becky will talk about this, but the next speaker was instrumental in campaigning for this for a long period of time to get it to this point. And the thing I like to point out with this bipartisan bill that has been had its reading now is that it's really useful to talk about the legislation itself, but also the process, the fact that this is the first bill that has resulted because of the rule of 61, where 61 MPs, backed it so that it could come out of the biscuit tin and onto the parliamentary agenda. So that's a really important point because, I think we want with a number of pieces of legislation we're advocating for it to get that cross-party support because that ensures it's more longer lasting in terms of its effects that we'll see. This bill requires companies making more than 100 million a year to report publicly on their efforts in terms of what they're doing to identify modern slavery risks and actions they're taken to mitigate and remediate harm. And they have to produce modern slavery statements to report on this, and there'll be penalties for non-reporting. It also gives some direction to the Human Rights Commission, my organization. So the minister can direct the commission to have modern slavery as a priority area. And there's also within the bill consideration of establishment of an anti-slavery commissioner. Now, the last thing I'll point out here is, it's a proposed piece of legislation at the moment, so it's just had its first reading yesterday, and now we'll go through the stages of consultation where people can make submissions on it. So there may be adjustments to this legislation, of course, as it goes through those phases where people may advocate for additional things to be added to the legislation or to help strengthen it and make it a robust piece of law. And that's where I will end. And I will pass on to Rebecca Kingy, who is an amazing human rights leader in her own space, is the ESG initiatives lead at ANZ, and has been instrumental in pushing this legislation to this point over a number of years. Over to you, Becky.
Thank you so much, Gail. Thank you for the kind words as well. And yes, to get to this point, there has been a significant number of individuals and entities and NGOs that have advocated, and I think it's a really proud moment for collective movement and collective progress in this space. As Gail said, my name is Rebecca Kingy. I'm a modern slavery specialist, and I'm also the ESG initiatives lead at ANZ Bank. So my area of work in the bank is leading and involved in our modern slavery and human rights program. So later on, we've got the amazing Nicola and Kate who are going to go into the weeds more of the bill itself, what the statement requirements are. And I'm going to preamble that with some context around the journey of this bill, the journey that New Zealand and New Zealand entities have been on. And it's been quite a long one. I actually want to start with a story, and I want to take us back to 2004. And this was an evening in the UK, and a police operator got a distressed call coming in saying sinking water from a panicked worker. What was happening there were 30 workers out cockling. They were out gathering sea cockles on the shore in Morecambe Bay, and the tide was coming in. These workers were not equipped at all for this work. They didn't know about the tides. They hadn't have any sort of health and safety briefings or any sort of structure around the work that they were doing. Actually, they were being heavily exploited in this industry. The tide came in, and unfortunately, 23 of the workers lost their lives that night. They drowned. And it's quite a heavy story to kick off with, but actually it was such a pivotal, shocking moment in the UK when this case came to light. It really spurred a cascade of reform and structural reform, legislative reform around modern slavery, because the UK just had this wake up that actually slavery, the severe exploitation of workers, of people, isn't a historic thing. It's a current thing. It's something that's happening, and it's embedded actually in the economic practice of businesses at home in the UK as well as overseas. So as a result of this disaster, there was the establishment of the Gangmasters Authority, which is sort of like the Labour Inspectorate equivalent in the UK. And then 11 years later, we got to 2015 and the introduction of the UK Modern Slavery Act. And you can say, gosh, this is a horrific case, Vicky, but 2004, it's quite a long time ago. And yeah, it is a long time ago. And it took that 11-year period to finally get legislation in the UK. And what it kind of signified especially was a shift of understanding that trafficking, forced labor, severe exploitation that falls under that umbrella term of modern slavery isn't just a criminal justice issue. It very much is a criminal justice issue. It very much is a severe crime. But it also is something that requires responsible business conduct in order to combat, because it's woven into the way, unfortunately, that capitalism has evolved, and it's costing people's lives, actually. So I thought the time period of 11 years was really significant, because here back home in New Zealand, we've also begun to realize we're not immune to this activity, that actually in New Zealand, we have cases of modern slavery. We have cases of human trafficking, of severe exploitation. And it's not something that's just overseas or detached from us. And it was in 2015, 11 years ago, that the first human trafficking prosecutions were laid in New Zealand for a case domestically. And subsequently, there's been, since 2015, 4 trafficking prosecutions, not all of them successful, a number of slavery prosecutions. And I've just here literally given some snippets of headlines. There are so many. I mean, we could talk this whole session on case dives of what's happened domestically here, but these ones always have sort of stayed with me. The child exploitation case of Circus Circus, where we had children trafficked and working in an entertainment industry in New Zealand. A recent case actually that was just prosecuted where myself and an amazing legal colleague, Clayton Walker, we really wanted trafficking to be charged, and it was a trafficking case, was the Hawke's Bay Paraminder Singh case, and he has been jailed for more than 14 years for exploiting and raping workers. So I think it's important to understand that modern slavery, the type of grievous activity we're talking about here, is often connected to other crime types, sexual abuse, rape, also types like money laundering, tax evasion, assault. It's a really complicated and devastating area. And it's not even just domestically in cases, but of course, the connection that New Zealand has through our supply chains, through the imports of goods. This is a number that was reported in 2023. So I imagine it's gone up significantly now, that we import nearly 8 billion in goods linked to modern slavery. So this is goods that we have and we see all the time in our homes, our coffees, our chocolates, our clothes, our garments, our electronics, and in our businesses as well. So all sorts of things that I think are incredibly relevant to New Zealanders. And we have this degree of connection that is far more apparent, that is sort of grown in understanding to us. Now we're here in 2026. It's scary, actually, that it takes so long for these issues to really start to show themselves in policy and legislation. But the reason I wanted to kind of talk about this broader journey in this broader context is so that we remember when we're looking at this bill, this isn't just a bill that's appeared because it's a nice tick box and it's a nice thing that looks good on paper for New Zealand's sort of legislative handbook. It's come as the result of people's lives, actually. And, I think it's scary how long it takes us to actually have infrastructure in place to address this correctly. It's also scary because there are key drivers that are really relevant for business. And I want to sort of talk about the other shift that's happened here. Like I've said, we've had the shift from just a criminal justice mindset to more of an understanding that this requires business responsibility. But we've also had a shift for business that this is not just something that you need to do. It's just a piece of light and fluffy that looks nice. Actually, this is a core part of management for business. It's a core part of risk. And that's been a real driver as well for why we've seen momentum in New Zealand and overseas of these regimes. So, of course, we've got stakeholder expectations. So that's investors, consumers, and others relevant stakeholders who now have high levels of scrutiny over what is happening in the conduct of a business, both in their operations and supply chains. We've got international trade and market competitiveness. And something I'm actually really passionate about as a Kiwi is making sure that we are there reaching our potential on the world stage, that our businesses that actually do, I think, punch well above their weight can operate in global markets. And the reality is, from my experience in working in these issues for quite a long time overseas, this is mainstream dialogue. This is mainstream dialogue in the corporate sector. And my concern has been that actually it hasn't been enough in New Zealand. And for us to compete and to be operating with confidence and competitiveness in those markets, we need to increase our maturity in this area. And the legislation is something that can assist with that. There's obviously as well legal and reputational considerations, and there's really high risks for businesses in these areas because of actually the fallout that happens from modern slavery. And as I've said from the initial story, it's really grievous. And so that kind of association with your business is obviously not just a breach of extreme human rights, but it's a breach of trust, and it's something that can stay with the business for a long time. So that sort of falls into that risk management and business continuity. And COVID was a really good example, actually, of how making sure that the relationships and the way that we do business in our operations and supply chains, including the way that we consider, prevent, address modern slavery risks, is important for business continuity, because businesses that didn't actually have maybe the best partners supplying their key goods and services during COVID actually had some significant disruption. And a really tangible example would be, factory workers that were supplying gear from an offshore site that didn't have appropriate health and safety. When everybody got really, really sick, the operations completely stalled. That was money just disappearing for these businesses that suddenly hadn't got really secure supply chains that were working and looking after their work as well. It has a flow-on effect. I'm not going to list every single sort of item that's happened here, but as Commissioner Gale alluded to, it has been a journey for New Zealand to get here. And way back in March 2021, I literally cannot believe it was this long ago, 5 years ago, we had the business community, partly for the reasons that I just outlined, calling for strong modern slavery legislation. Actually, the legislation, if done well, can help businesses reach that global competitiveness and standard. And so there was strong support for this. We had 100 businesses sign a letter. There was a 37,000 strong petition delivered to government from the public. And then we had real movement. We had the government establishing the Modern Slavery Leadership Advisory Group, which was chaired by Rob Fife. We had a public consultation with over 5,000 submissions coming through there and 90% of those in support. So that was in 2022. We move now into 2023. There's a strong announcement from Labor. This legislation was going to happen. We had investment managers coming in strongly as well. But then in 2024, we had a real change of gear. Things really shifted in tone. And actually, the government of the day deprioritized this legislation. So it's been a bit of a yo-yo for New Zealand entities. It's been a yo-yo for all stakeholders involved in this. And the world has sort of been looking at us saying, is it happening? Is it not? Stop starting. And this is where this really sort of unique pathway cropped up. And I really need to give credit to my colleague, Rebecca Armstrong, who has been instrumental actually in just continually ensuring that this stays on the dial. And it was with Rebecca and our colleague, Jacob Parry, that we worked with MPs from Labor and from National to draft a consensus modern slavery bill. It was really exciting that there was still appetite within the House, within Parliament, and there was actually political consensus around this issue. And I think that's hopeful personally, because I don't think modern slavery should be a contentious issue. And I also think it's hopeful pragmatically, because we really need to see policy consistency in all areas at VSG for entities. But in this area, it really helps businesses if they can have that confidence that actually we're all on the same trajectory here. We're all working on the same set of values and effectively the same policy landscape across the House. It's where I'll say as well, on the record, no offense taken for any critique of this bill or for opinions. In fact, I robustly encourage it, because what the sort of mandate was to try and draft a piece of legislation that could be supported across the House. And that's actually no easy challenge when you're also trying to make sure it has compatibility with international jurisdictions, that it actually fits what it's supposed to do on the tin. It actually is going to have impact, trickle down impact on those on the ground who are suffering from modern slavery. And that's actually also going to be appropriate for our domestic context, because I just think New Zealand doesn't have the same infrastructure that perhaps other countries have around this issue. And so the first draft that we did really tried to address some of those gaps so that it was a comprehensive regime, and to make sure that actually businesses aren't having to step into roles that they shouldn't, because it's a complementary role here. We've got the role of the state and we've got the role of business, as well as, of course, civil society as well there. So this sort of happened at the end of 2024. We published this bill. And the idea was that the rule of 61 could be triggered, that because there would be enough support across the House from 61 non-executive MPs, the parliamentary standing order rules could be triggered and the bill could move up through a member's bill. It could automatically be introduced, as opposed to a government bill, which usually goes priority through the House. So a really, really unique mechanism. And as we all know, there's a bit more of a bumpy ride. National put one in, Labor put one in, they pulled them out, and we actually managed to get a joint one introduced in January. And just last night, this bill had its first reading, and it's passed its first reading with 112 across the House in support. It's got a way to go. It's got tweaks and design that needs to happen, but it's a really solid starting point. And what an encouraging moment for New Zealand to show that we can work this way across our political parties. I'm coming into land because I know we've got a lot to get through, and I'm very conscious of time, but everyone will, of course, wanting to know what comes next. When do we need to get ready for this regime? And so after last night, it's past first reading. The next stage is for select committee, and it was been specifically referred to the Education and Workforce Committee. So that committee is made up of MPs that will have, a more of a sort of that area focus on the bill. And normally there's usually a 6-month period for bills to go through select committee to allow time for all of that consultation, etc. This is intended to be an expedited timeframe. So it's been requested a 4-month period. I think the date sort of floated in first reading yesterday was the 31st of August. And so that's quicker, but that means I would say start getting ready, start thinking about how you want to engage in select committee. Think about what the position is of your business, of your entity, where you think this bill could be improved, where you think it works for New Zealand, where you think it doesn't. And I think it's just so important that we engage in this democratic process and get something that's really going to last the test of time for us as a country. Then the bill would come back from committee with the report. So they'd report to the House, and that's where you have your second reading. And there's a debate, effectively looking at if there needs to be changes to the provisions, really examining what submitters have said, and that kind of the space really to get the bill shaken up. And then you go through to your third reading if this is passed, and that's where you have your final vote. So effectively, yay or nay, is this going to become law? If you have passed and you go through royal assent, it does become law. And currently, what's written into the bill is a 6-month commencement period after royal assent. I mean, who knows? That could even change because all of it's sort of up for debate in select committee, but 6 months is a pretty fast commencement period. So sort of my message would be 2 things. If you're an entity on this call today, think about in the short term how you're going to engage in select committee process, what you want to make sure that our government, our parliament are aware of in terms of getting this law to be absolutely what we need for New Zealand. And secondly, what do you need to do as an organisation to get ready for this regime? And you know what? You've already taken a great first step in registering for these workshops, and you're going to hear from our fantastic experts from Chapman Tripp who are going to go into the weeds more of the modern slavery statement itself. So you know what it is that you need to be reporting on. And what I need to emphasize is, you know what? You'll be able to do so much better reporting if it's the activity that sits behind it that takes a priority in your organisation. I will hand over to Nicola now, and just want to say a massive thank you to our hosts, Deloitte, to Chapman Tripp, and to SBC for having me on this call, and for all the participants for taking this initiative. And it will do you well as you start to prepare for this regime. Thanks, everyone.
Thank you, Rebecca. And I'm actually going to jump in first, and Nicola's going to kindly share our slides, and we're going to tag team this a little bit. But while we're sharing the slides, I just wanted to thank you, Becky and Gail, for your contribution, and what an auspicious day to be having this conversation hot on the heels of last night's historic first reading of the Modern Slavery Bill. Rebecca, I think you're now a wee bit Parliament famous, having been name dropped so many times in the various speeches, and that was very well-deserved recognition of you, Rebecca Armstrong, Gareth Perry, and the many other individuals and organisations who have worked so hard, as your timeline shows, to get us to this point. So this is a really timely conversation. I'll talk a little bit about what's happening next with the bill, building on what Becky's just said, more about what's in it, and what you need to know as an entity that may be captured, which I am assuming you are if you're on this call. Then my wonderful colleague Nicola will talk a bit about the mechanics of it and how it will work when you're preparing and submitting a modern slavery statement. And I think this is really Nicola's moment to shine, having now over 10 years under her belt of work in this space, dating back to her time in the UK when the UK modern slavery legislation came in. So she's got a storied history there. So I know many of you on the call will already be reporting under the Australian regime, or maybe even the UK regime, or otherwise thinking about these issues in the context of supply chains you're a part of. So this is a really opportune time to take a closer look at what you've already got going on. So skipping ahead about the bill itself, look, Becky's already mentioned some of how we got here and what comes next. The reading took place last night. We had 112 votes in support of that, and just 11 in the negative, which was from the ACT Party. The bill will now move to the Education and Workforce Select Committee, and the due date to report back is the 31st of August, as Becky said. Now, that is technically in the pre-election period, which starts 3 months before the general election. So that does cast a slight question mark over what will happen after the report back, and whether the passage will in fact be technically possible ahead of the election. But that is certainly faster progress than many of us were expecting if we had been having this conversation a week ago or even a few days ago, all other things being equal, given where the bill was at in the parliamentary order paper. It would have likely been some time before it had its first reading, let alone being passed. But there was clearly some very clever political manoeuvring in the background to get this across the line, with Labor having made its support for the India free trade agreement conditional on prioritisation of this legislation. And I'm sure in the Q&A, Becky might be able to shed some more light on what's been going on there. So it's really one to watch. But the key message for those in the virtual room today is that we expect the committee to be calling for submissions relatively soon, given that shorter report back date. So be prepared to engage if that's something you're looking to. So who is in scope of the regime? On the next slide, a little bit more detail on that. Gail's already touched on this. It mirrors Australia in terms of the revenue threshold of $100 million. So it is large entities, but it is essentially all entities. The definition of entity is quite broad. So it's companies, yes, listed issuers, but also privately held companies, and a range of other entities, as you can see on the slide there. So it will be quite broad, about 700 entities or so that are expected to be captured. Pretty broad coverage when you compare it to, say, what we're now looking at with the climate disclosures regime, for example. So what's required then of those entities that are in scope? So Nicola will come onto this in a bit more detail in terms of what needs to go into your statement, but I'll just note that it's both actual incidents of modern slavery that occur in your operations and supply chain, as well as risks you anticipate. Gail touched on this distinction between disclosure, your reporting in your modern slavery statement, versus due diligence. No mandatory due diligence is proposed under the New Zealand legislation, which is at the moment the same as what's in place in Australia and the UK. But those who are captured will have to describe what they're doing in response to those risks that have been identified, which essentially by definition requires you to kind of look closely at that. And we expect will have some kind of a normative effect in terms of raising expectations and business practices in this space. Equally, the requirement to think about and disclose your risks in this area will require a level of understanding and engagement with your supply chain. So I think necessarily by virtue of having to look at these issues and disclose against them, there'll just be more conversance in the business community with what this looks like in the context of operations and supply chains. So I'm going to touch now on the liability piece. Last night in the House, there was some discussion of this bill having teeth, and indeed it does, which is a key point of distinction with the Australian regime. So we do have fines, offences for failure to report under the legislation, and potential additional pecuniary penalties as well. There is also director and officer liability potentially, where there's direct involvement through that person having either authorised, permitted or consented to an activity or a contravention of the legislation, or accessory liability where there's an actual or constructive knowledge with the availability of a defence where that person has taken all reasonable steps to prevent the contravention. And so this mirrors wording that we have in other legislation. So we do have some idea of how this could work in practice, but it is a new area to have penalties in a liability regime like this for this kind of legislation internationally. On the next slide, just a little bit of a clarification on sort of what's not covered in terms of the penalty regime and the liability regime under the bill. So just to underscore that the offences in the bill, and therefore liability arising from those offences, does not relate to modern slavery incidents themselves, but rather for failing to comply with the obligations in the legislation. So that's the reporting itself, or for making misleading statements within that reporting. So for example, there isn't any liability created for failing to undertake due diligence because it doesn't impose a mandatory due diligence obligation as currently drafted, or for example, failing to respond to an incident that might have arisen. The liability that currently exists under criminal law or potentially employment law, when we're thinking about exploitative labour practices, covers the actual legal liability for those incidents themselves. So just before I pass over to Nicola to get into the nuts and bolts of a modern slavery statement, we thought it might be useful to just touch on what we expect to be the key items of interest arising from the consultation and select committee submission process. And we do expect there to be wide interest given the scope of the coverage and the fact that this has garnered a lot of interest and media coverage too. So we expect there to be discussion around the reporting threshold itself. Is that fit for purpose in a New Zealand context? The liability regime that I've just talked a little bit about, whether that works and how we expect that to function, and whether it is too onerous or not onerous enough. There's this question about mandatory due diligence and whether that ought to be part of the New Zealand regime. There's currently discussions underway in both UK and Australia about whether mandatory due diligence should be incorporated as part of reforms to those pieces of legislation. So that could be part of the conversation here too. And we also expect there to be discussion around whether reporting on actual incidents should be part of the mandatory disclosures. It's not in Australia, so that it would be a point of difference if we were to include that. And whether it's helpful to have guidance or support from government for both the entities who are captured as they upskill and prepare to comply with this regime, but also for the likes of media, for example, to upskill the understanding of and conversance with these issues to enable responsible engagement and reporting on these issues as these statements start to come out into the market. So I will stop there. That was a bit of a whistle-stop tour, but I'm going to hand over now to Nicola, who's going to jump into the detail of what these statements need to look like and how you can think about starting to prepare.
Thanks, Kate. Kia ora koutou. I am going to dive right into it, and it is such good timing to be with you all this morning because it was very exciting dialing into the first reading last night, and Kate is right that really moved up the agenda faster than a lot of us were expecting. So incredibly impressive performance by those behind the scenes on this. It's helpful to just spend a moment looking at the key terminology here. The bill does explain the types of conduct that is expected to be covered by a modern slavery statement and a modern slavery work program. And I think that the content that Gail and Rebecca have talked us through already really shows that this is something which is going to be potentially a larger issue than a lot of people realize when they first think about what could be covered by modern slavery. And I think one of the things that will be really useful for businesses as they're starting to get up to speed on what might be covered and what kind of conduct and what kind of risk assessment they need to be doing is to focus in on the examples of modern slavery that have already been disclosed over the last 10 years now by entities in the UK and also by entities in Australia, because it is really helpful to see those concrete examples and then to think about how you could protect for some of those situations in your own businesses. So conscious of time, I'm going to leave these points on the slides and we'll circulate these slides afterwards. I'm going to focus on what needs to be included in a modern slavery statement according to the proposed draft bill. And I think, Rebecca, your comments on the welcoming feedback and input, particularly from the business community as this bill works through the select committee process, that is going to be really important to make sure that this is a workable system for all of the organisations that are going to have to prepare these statements annually. And we've just come out of a very similar process through the climate disclosure regime, where we did see a lot of pushback once the regime was up and running, because it was seen as being too onerous for business. And I think one of the things that I know the team has already been thinking about getting this bill into position and then thinking through the select committee process is how can we make sure that the bill is right-sized for the New Zealand environment so that we can get this process up and running, we can get some really good risk management processes underway, but we don't risk that same type of political pushback which created so much distraction on the climate reporting regime. So you can see there's a couple of call-outs we've shown against the Australian legislation. So one of the key changes is that in Australia, you're not required to describe in such specific terms actual incidents within the operations and the supply chains within the reporting period. Now, this is really important when you're thinking about your downstream supply contracts. If you are required by the legislation to disclose actual incidents of modern slavery in your supply chains, you can imagine it could be very easy to get into a situation where a potential incident is being reported online about a supply chain that might be several tiers down your own supply chain, and you may not actually have the contractual powers to be able to get much information about that, and it can put you in quite a difficult position in terms of what you can do or should do about the incident, and then at the reporting stage what to report and how to report that. So if that does stay in the legislation and it's been put there very specifically as being a requirement separate to reporting just the risks of modern slavery, then businesses really need to start thinking about their abilities to get that information out of their supply chain, including through their contracting. Description of known or anticipated risks is very similar to what we have in Australia, and also the actions taken to assess and address modern slavery risks. Slightly different wording, but a focus in both on due diligence and remediation processes. So again, as Kate says, no requirement for mandatory due diligence, which is, of course, now being recommended overseas. But certainly if you have to describe your own assessment as to how you are preventing, addressing, and mitigating modern slavery in your supply chains, it can become quite uncomfortable for a business to say, we are not able currently to address any modern slavery risk in any of our supply chains because we don't do any due diligence. And we'll speak to Francis in a moment, who'll be able to give us a real life understanding of how to balance that really difficult calculus of how do you know where to start and when to stop in terms of the due diligence that you might be doing. And then just on the second slide is the second half of the requirements in the legislation as to what needs to be included in your modern slavery statements. Again, very specific in the current bill in New Zealand, requirement to disclose the number of modern slavery related complaints that have been received, as well as measures taken to investigate and remediate incidents. Again, in Australia, you have a similar disclosure requirement in terms of actions taken to address and remediate, but the specific number of complaints isn't required. So it's similar to that point earlier around the number of actual incidents, just we don't have quite that same level of specificity in Australia. And then we've got a similar requirement for describing how you assess effectiveness, but there's an expectation in New Zealand that also reflects a continual improvement obligation. And then we have a requirement to describe training and consultation. Again, training's not required in Australia, although it's a very common disclosure across a lot of the modern slavery statements there. And the description of consultation is a little bit different. The New Zealand bill is very deliberately speaking about consultation undertaken with your employees, while the consultation process in Australia tends to focus more on consultation across subsidiaries, entities in a group, as opposed to digging down to that employee level. And then, as we've covered already, there's a very different regime in place proposed in New Zealand in terms of failure to comply with offences and penalties, director management liability, and then exclusion from public procurement processes. While on the Australian side, to date, we've just had a ministerial power to request an explanation and publication of those who haven't complied. So we'll see where that lands as we go through the select committee process, but that's a very deliberate shift and a deliberate leaning into some of the learnings from the Australian regime in particular and the UK regime over the last 5 to 10 years. So just for a couple of minutes, we thought that it would be useful to make this just a little bit more concrete by whipping through a few examples of reports out in the marketplace to show the kind of resources that are out there to avoid New Zealand entities having to reinvent the wheel on a lot of this content. There are some really fantastic examples both in New Zealand already, KMD being one of those, but also overseas. And so you can see, for example, the description of entity and supply chain details, some really great graphic content, here, in an example from Fortescue around their operations, supply chains, where they are, how many, the contestable spend across different jurisdictions. In terms of reporting particular incidents, there's some good examples in the public around the number of modern slavery incidences in operations and supply chains being reported year on year, and targets being put in place by companies, as we've got an example here. You can see in the commentary, there's commentary around, no confirmed instances of modern slavery. However, we did investigate a number of labour concerns, et cetera, and then disclosure of some of that investigation work. Another one here around actual incidents and references to supplier reports, so providing disclosure of content that you've had from information coming up through the supply chain, and then specific reporting of substantiated cases and allegations and the results of investigations internally. Westpac over in Australia had a neat a description of known or anticipated risks of modern slavery across their supply chains, and just some useful breakdown across the way that the modern slavery shows up for different parts of the supply chain in the banking sector. I know ANZ does this beautifully as well, and Rebecca will know that intimately. In terms of actions taken to assess, prevent and mitigate risks, again, some of this came from Coles over in Australia, explaining exactly how the ethical sourcing program that they have there is working to assess, prevent and mitigate. And you can see them breaking this down into description around due diligence, description around grievance management, description around remediation. Which is just useful as you're thinking through the tools that might work well for you in your business. Here there is just an example of how the grievance mechanism process would work, and there are some really good examples of this. I think this is one of the tricky areas, is not just to identify your risks, but also to work out how are we going to address these issues when they are raised, and what are we going to do about them, and what is our commitment to remediation of a concern that might be raised, and the difference in approach depending on whether that is something that you are directly responsible for within your operations, or whether it's something that you're more indirectly linked to across your supply chain. And the good news is that there is a lot of international guidance that New Zealand can draw on there, that draws from, as Gail said at the beginning, the UN Guiding Principles on Business and Human Rights. Again, we'll send these slides out so you've got some examples, but managing grievances, managing complaints, details around how that has been done, lots of examples in the market. And then assessing effectiveness and continual improvement. I thought some of the examples from Coles here are around priority activities that had been undertaken, and then what has changed within the reporting year or the last couple of years, and reflection on where areas to improve are. That shows some of the more sophisticated reports offshore who've had a few years to get used to this now. Lots of good training content, and actually disclosing trainee attendees' views about where they are sitting in terms of their understanding of modern slavery. That's going to be something that will be a big lift for a lot of New Zealand businesses in the first couple of years, and the different types of training modules or options that might be provided. And then just to reiterate a couple of technical points, that these statements are going to be published on a public register, which is the same offshore. And you can see an example here from the Australian Modern Slavery Register. We've got about 30 or so New Zealand modern slavery statements a year, or New Zealand company modern slavery statements a year being published on that register. So again, some really great examples. One of the points for the Select Committee to look at, I think, is that the balance date is that the current reporting requirement for statements is on a fixed 31 March rolling deadline. So it currently isn't designed to align with an individual business's balance date and their annual reporting suite. It's currently set at a 31 March universal deadline. And I wonder if that's something that may be discussed in Select Committee, because I know a lot of businesses, particularly having come through the climate regime, may be wanting to shift this to align with their balance date, just so that all of their internal governance can line up. So just before we dive into a discussion with Frances, just a couple of really key next steps to take if you are captured by the regime, and not trying to preempt a whole work program here, but just to think, first of all, do we want to engage in Select Committee? I would say that is going to be a key decision just in the next couple of months, because the Select Committee will need those submissions in by, I would say, at least end of June, in order to consider them to report back if they keep that end of August report back date. Consider what you're doing at the moment. So think about, is there anything we're doing currently that actually is protecting us in some of these areas? And if we looked at that against the disclosure requirements in the bill, where would our biggest gaps be? Any early resource required for getting your board and your exec teams just quickly up the curve on this, I think that's a really smart move, so that they realise the the challenge of reporting under a regime like this, and also the opportunity for the business, going back to Rebecca's comments, and thinking about how you can integrate modern slavery into some of your existing governance processes as opposed to reinventing the wheel on this. And a lot of what we're going to be covering in the second workshop, which we have the privilege to present with the team here, is going to be focused on the key elements of the actual nitty-gritty of the modern slavery work program, so that you can get a sense of how other businesses have done this and ways to get that up and running, perhaps more quickly than a lot of us thought might be necessary. This is all content that we'll be covering in the second workshop, but I just wanted to flick the screen up because there are hundreds of these squares that we could put up to spark thoughts about what might be particular risk indicators in your business. And I think thinking about some of these really practical issues can actually help you think, what are some of the things we could start doing and what do we need to be looking out for in our business, because it does really differ, obviously, according to the different sectors. So I'm going to stop sharing and I'm going to introduce wonderful Frances Blundell, who is with us here from KMD and who has been living and breathing this content for the last couple of years. Frances is the Chief Legal and ESG Officer and Company Secretary for KMD. And as some of you will know, KMD is a certified B Corp, which means that KMD has gone through the rigorous process of having its business externally certified as meeting high standards of showing positive social, environmental performance, accountability, and transparency. It's no mean feat, and KMD was one of the early businesses to achieve that certification under Frances's leadership. So, Frances, we're really delighted to have you here today. I'm going to ask you to talk just briefly about the work that you've been doing in this space. You've published a number of modern slavery statements that are out in the market, and I no doubt will be looked up by many people on this call today as they're starting to get a sense of what they need to do. But if we could, maybe I'll just start with that, and then we'll cover a couple of quick questions too, Frances.
Thanks, Nicola. Morena, everyone. It's great to be able to join the conversation today. As Nicola mentioned, KMD's been completing modern slavery reports for a number of years now, primarily under the Australian regime. We started back in 2021, I believe, as separate brand statements, and then from about 22 onwards brought them together as group statements reporting for all the brands in our group. So that's our Kathmandu, which many of you here in New Zealand will know, Rip Curl, surf brand, and Obo's our footwear brand based in the US. So we've combined our reporting to talk about our entire sort of footprint and supply chain and impact from a modern slavery perspective. As you know, ESG is really embedded into our purpose and vision and what our brands are about. And as a listed parent company on NZX and ASX, we're obviously very focused on transparency in our disclosures. So a lot of the sort of theming and narrative through our B Corp commitments had set us up well to start this work when the Australian legislation first came into force, and has enabled us to really continue our work plan that was already in place, but we've certainly learned a lot along the way.
And that's one of the things that I think would be really helpful just for this audience to hear, Frances. What have been some of those really key learnings as you've gone through this journey? What were some of the hardest parts of moving from having to sort of go from not having any modern slavery content out of the market to having a really credible modern slavery and mature modern slavery disclosure in the market? And is there anything that, looking back, you wished you'd thought about harder right at the beginning, which is where a lot of the participants on this webinar currently are?
Yes, there'll be lots of examples of that, but I think when I reflect back, at the beginning, we really talked a lot about our commitments and our intent and our aspiration, which is where a lot of people will begin. We've evolved over reporting year on year to more evidence-based disclosures. So it's a difficult balance to get right, particularly to ensure consistency in our disclosures where we have quite different supply chains across our brands as well, and trying to bring it all together into one statement. I'd say one of the key challenging areas, and what just listening to the conversation today and sort of reflecting on how we approach it, is getting comfortable with being transparent about the imperfections that you are going to find, not pretending that they don't exist, acknowledging and sharing the challenge. And that is very much how we've approached this entire area. We are trying to work with those in our supply chain to address underlying causes. That's the reason why this legislation is powerful, and why disclosures actually help drive us towards addressing a really important issue that's systemic and goes much broader than any of us can control. So a credible disclosure that prioritises and honestly shares the challenges and risks and the efforts that are being made is a huge opportunity. It's a hard shift. It really have to reframe what success is internally. There's an instinct to try and aim for a clean report that, we didn't find anything, but actually we've spent time educating our teams and working with our suppliers to understand that finding risk is not failure. It's evidence that your due diligence system is actually working. So that's a conversation we've had both internally and with supply chain partners. If you have a deep supply chain, there's often a hesitancy for suppliers not to share their issues and challenges with you. But by building those strong relationships and helping your suppliers understand that they can share with you how your business decision is creating risks for them that could create or exacerbate a modern slavery risk, and that goes to your purchasing practices and your payment timeframes. All of those things are risks that can flow through to suppliers and exacerbate a modern slavery risk. So making sure you've got a good dialogue, a really good relationship that is helping everyone share how we can work together to address those risks is for me a really big shift, but a really powerful and an important one, that there's a real achievement in being able to say, we identified an issue and look, we did something about it. So in terms of what do I wish we'd done better or earlier, I think disclosures are just a first step, and it's going to be a really iterative process as you learn. Be really prepared to engage with stakeholders across your businesses to revise purchasing practices. You've got to invest in capability to do this well. So you've got to engage sourcing, product, commercial. It is not a job to be isolated to one person or just a department. It's a responsibility that needs to be shared outside of a sustainability or a reporting function. So establishing that at the outset, making sure you set the tone from the top, and having everyone working together on sharing the how do we do this well, is really going to set you up for success down the track.
And if you were looking back to some of your first reports, Frances, it was a really common question in this area is, I just don't know enough about my supply chain, and I even if I take some steps and send out some questionnaires, I'm still not going to know. I'm not going to have full visibility even of some of my tier 1 suppliers, let alone tier 2, tier 3. So how does someone, how do you get the board comfortable that you're going to have to say that quite transparently in your first couple of reports, especially as a program is still being built within the business?
It is really difficult and really quite challenging work. If you have a supply chain like ours, as a consumer goods, our supply chain's deep. We can see a level of our tier 1 manufacturers, and we've spent a focus of our work program trying to trace through and again understand exactly where the component parts are coming from, so that visibility enables you to improve year on year about the evidence and information you've got. But to start with, we focused on what the information we had was accurate, informative, defensible, rather than whether it was complete. So explaining our due diligence framework, the systems we had in place, how they operated and what actions flowed, and being really explicit about where you have limitations. It is a little bit confronting. Perhaps people don't understand how supply chains work and realise that actually we don't have the visibility. But overclaiming your capability is a very quick way to lose credibility. I think that a couple of things we've done is get the tools that help you to actively monitor suppliers and listen to the perspective of the workers in the supply chain and hear from them about their challenges and opportunities. So for anyone who is involved in carrying out sort of surveillance audit work, we've tried to move away from the traditional audit. Still has a place, but recognizing it has limitations, and find tools to hear the voices from those who could very much be at risk, so that they feel safe in a way that they can be anonymous but share challenges, so that you've got a way of hearing about those risks and taking action when it may not match the what you're being presented with in a traditional audit. Another way that we've tried to evolve over time is developing a real risk lens on how we approach. So not just factory level compliance, have we done an audit, tick a box? What's the risk assessment in terms of the overarching commercial model in the supply chain? What's the business materiality about where that's the goods coming from that supplier have to your overall picture, and focusing your efforts on where you can have the biggest impact. So a framing that helps steer a report away from being descriptive to being a sort of risk-led and more evidence-based statement actually also helps you with real decision-making for your procurement team, your sourcing team, so that they've actually got the information they need at their fingertips to help make decisions about which suppliers to work with. This becomes a really important piece of information alongside quality, time frame for delivery, pricing. But what else do we know that we want to make sure is in the mix, and having all of that linked together?
Yeah, that's brilliant. And so just before we open up for wider questions, are there any sort of really key sort of useful changed behaviors or conversations that you've had as a result of going through this disclosure journey? Because I think that's, if you can explain that up the chain to an exec and board, then that helps get that buy-in for the really tricky work that has to happen now.
Yeah, look, it's certainly been an interesting one, that the contribution to awareness that our disclosure obligations have provided over the years, from understanding that shared responsibility between procurement, commercial, supply chain teams, cross-functional, legal, sustainability, right up to the board. It definitely brings modern slavery risk from something that feels abstract to a context of an actual real decision-making piece, part of the core conversation about who in our supply chain we want to work with and why. There's a real opportunity with reporting obligations to embed a system for meaningful due diligence to address a really important risk with human rights, understanding how to do that well, rather than a minimum set of standards that are just about compliance, but a real conversation. I think that the development of the process itself has been really valuable internally. It's also helped us think better about policies and processes, and helped our business stakeholders be more accepting of change, to help us be better as a business partner to our suppliers, because we can actually talk to the narrative of how our purchasing practices have an impact through onto the vulnerable workers at the end of the supply chain. Externally, it helps with the disclosure, being able to benchmark yourself against peers, check your processes against other businesses. Are you doing too much? Are you doing too little? And helps provide that direction about where to go as you refine and update a strategy. And as a listed entity, it's helped us have a lot of good conversations with current and prospective investors around, for those who are really interested in social impact and long-term value in their investment decisions. So being able to share and have meaningful conversations about, not just do you have a statement, but how are you managing this risk and how are you responding when issues arise?
Yeah, that's so helpful, Frances. And I was just thinking too, at the moment when there's so much pressure coming onto supply chains, and whether how confident you are in your supply chain, that this does give you an excuse to get closer to some of those suppliers in a way that you may get some broader relationship benefits from that if you can do it in the right way. So look, why don't we're going to hand over to Meredith Dawson-Lowry, who is a director at Deloitte and working in this area. Meredith, there you are. You can take us through questions. I'm sure the group here will have a lot of questions for all of the speakers today.
Kia ora. Thank you, Nicola. So I'll just kick off with a question to Frances, and thanks so much for taking us through this experience that you've had. And I can see year on year you would have taken away many lessons from this process. What would you say has been the key sort of mind shift over that sort of 6-year period that you've been reporting under the Australian legislation?
I think it's that key part about viewing this as capability building, not compliance. So there's an opportunity to really think about how to make your business more resilient, looking at a risk that has a key reputational impact on you if this sort of thing comes out in those media stories that we saw shared earlier. There's a lot to be gained from understanding the transactions that happen through the supply chain that maybe you can't see as well until you ask. And I think that the organisations that do this well will be the ones willing to sit with that discomfort and use it to drive better decisions.
Fantastic. And as the New Zealand legislation comes online and you're trying to sort of harmonise your reporting obligations around Australia and New Zealand, do you have any initial thoughts around how you're expecting that process to look?
We've actually had to evolve our reporting over a number of years to cover multiple jurisdictions. So we currently are caught under the not only the Australian, also Canada, California and the UK. So our focus has been to evolve our statements to remain coherent while still meeting the specific requirements of each jurisdiction. So it is a challenge to try and make sure that you cover everything that needs to be covered to meet all the requirements, but trying to produce one statement to include everything rather than falling into a pattern of different statements for different jurisdictions. It's a lot of time and resource. So we've done that through trying to put in sort of an appendix on the back to point to where certain requirements are covered. So yes, we'll have to do that process again with the New Zealand legislation and think about that gap analysis and anything further to integrate.
And I suppose this is also a really good opportunity to mention to organisations on the call now around that consultation process and how this is a really good opportunity to sort of flush out any sort of thoughts or concerns around harmonising our reporting with other countries' legislation. Maybe I'll direct that question back to Nicola. Are there any thoughts that you'd like to add around that consultation process?
Oh, look, I do think it's really important that businesses do engage, and there are some good questions coming through around, what does this mean for small, medium-sized enterprises? And certainly that's something that government can help on. It will be useful for government to hear through this select committee process exactly what kind of support businesses are going to be looking for to be able to get this content up and running and build on the experience of Australia particularly. But as Kate mentioned earlier, getting real granularity over which issues may be disproportionately time consuming or difficult for businesses to do and may cause that kind of pushback that we don't want, it would be really useful to flush those out early so that we can get a really good regime up and running and then allow that regime to mature over time, as it has done in Australia and UK particularly.
Fantastic. Yeah, and we've had a few questions. We've had a number of questions related to, whether we're reporting on known incidences in the supply chain, and we touched on the discussion. We touched on our ability to flush out those known incidences. I really liked, Frances, your thoughts around that mind shift change of really getting the organisation quite comfortable with surfacing issues. And actually, if you're not finding any incidences, then potentially your due diligence processes aren't actually working. And it's about really bringing all your suppliers and your governance and leaders on that journey to understand that highlighting those instances is actually part of that journey. Are there particular systems or audit shared repositories that KMD brands are dependent on to really prevent that, to make it more efficient, I suppose, to surface those issues within your supply chain?
I would say the tools we've adopted, the focus has been more helping reduce audit fatigue, which is something, again, for businesses like ours who know you've got a wide supply chain of even tier one. We have sort of over 160 tier one factories alone. When you're asking, we as an individual brand asking them to complete an audit, each other brand that they work with is asking them to complete an audit, that's a big burden. We've used the HIG facility social label module tool, and we also use the environmental module that's part of Cascale Worldly for anyone in our industry. Those are tools where the supplier can complete their social assessment themselves. They can have it verified as well, which gives you a good amount of independent rigor to know that the information's been interrogated. They do it once and the results are shared with all of the brands that they're manufacturing for. So that's been a really important evolution in our work program over the last 5 years or so to help give us the information and visibility we need. But for the supplier, they just do it once and then they have the benefit of sharing that with a number of parties. We've obviously helped support our suppliers to make that transition through background information on how to adopt the tool, even to a little bit of funding for some to just help get them onto that platform. Another really important tool we use are called worker voice tools. So this is ways where we've got anonymous surveys, so QR codes in the factories where the suppliers can the workers can actually send us information. It's very anonymous. That means that the supplier has to permit that to be in the factory. So that takes a bit of onboarding and helping them understand that this is a good thing for all, but we get to hear directly from the worker without the sort of fear of reprisal from the supplier of what they may want to share. And that's proved really useful. We have we have issues come through and then we can take action. We can go, how can we help with a support program, training, policy change to address that?
Fantastic. We've got a question here. Is there any formal proportionality mechanism in modern slavery reporting frameworks, or is it mainly applied in practice based on risk, size, and organisational complexity? And a connected question, we've also touched on the challenge of tracing supply chains beyond tier one. in the context of the current form of the legislation, what is the guidance for people on the call around how to prioritise where to focus due diligence? So whether that is based on the particular sector, size of the organisation, or the tiers in which they'll be tracing. And that could be a question for Nicola or for Francis.
Just really briefly, that there isn't clear guidance on that in the legislation, and there also isn't in the equivalent legislation overseas, and that's part of the challenge of this type of work, is that really there is a lot of judgment required internally as to what is appropriate work to be doing and what is appropriate work to be disclosing. And I think, Francis, having lived through this, you touched on before the importance of working out what your most material issues or most salient issues are, as you often do in a materiality assessment in this kind of work, and that has parallels into, say, the climate disclosure regime and other disclosure regimes too. But here you really do need to make those judgments internally to work out what is important for us to disclose. And for example, a known incident, another question there around what is a known incident, that there is a graduation as to when an incident might be surfaced on social media versus when you actually have some proper reporting on it from your supply chain. And those decisions are tricky, and they will have to go through a proper governance process. And that's why it's worth talking through, well, how are we going to approach this in our business, what makes sense for us, so as not to set up a disproportionate process for the business, because a lot of this really is around zeroing in on what are the most material challenges for us and what can we do about them realistically, and then just disclosing that transparently.
Fantastic. And I will just mention, for those of you who missed it, we had a masterclass series based on the Walk Free Foundation Modern Slavery Benchmarking Tool. And those resources are housed on the SBC website. So that's actually a really good framework to use in terms of assessing where to focus due diligence efforts. And to Nicola's point, given the legislation doesn't stipulate specific tiers to be focused on for due diligence, it's quite a good benchmarking tool to use in terms of where to focus efforts. I think we've got a few more minutes to refer to some of the Q&A questions. What does the consultation undertaken with employees versus controlled entities support in terms of better or worse practice than compared with Australia's Act? I'm not sure if that's one that you'd be across.
It was directed to Jay. I think Jay was able to speak to that one, Meredith.
Oh, great. Sorry.
Hello.
Jay, would you like to jump on to answer that one?
I thank you for the opportunity. I think I clicked the wrong button. I do not feel like I am equipped to answer that. I could give it a good go, but I think I might defer to Nicola, given her expertise in this space.
Well, I also just wondered, maybe Rebecca, I don't know if Rebecca, you wanted to speak to that. I mean, I was interested in the fact that distinction had been put into the bill, because it did really focus on getting a disclosure requirement focused on how have you talked to your employees about what you are doing in this space, which I think is actually really positive to have that clarity there. But I think it's probably an example of where we're learning from the experience that the Australian regime has. But Rebecca, you may have more insight there too.
Hello, I've got baby Walter joining me, sorry. Yes, I think what the aim is, and the wording is a bit clunky in some places in my personal opinion, partly because of the gazillion versions that this bill went through, but I think it's promoting genuine engagement as much as possible with those that make up a business or an entity across its supply chain, across the different entities. And obviously that is making sure that you hear from your workforce. And I think because actually as well, I think a key word that often gets missed when we talk about this is it captures operations and supply chains. And so that actually includes an immediate workforce. And for some businesses, if you've got offshore workforces, that's an increasing thing that happens. It's important to make sure you're doing due diligence on your own employment systems. And a way that, and I love that what Gail talked about in terms of what the Commission covers, there's also a lot of positive things that businesses do around their own employees that help prevent modern slavery, and that shouldn't be lost from the dialogue, and that should be celebrated. So the protections that are in place for workers and the way that businesses have really good systems in place around health and safety, the way that there are good things in place around pay equity. Those are all things that prevent modern slavery and that prevent exploitation. And it's important to remember that actually you may be thinking, oh my goodness, my business is so behind on this. You're probably doing more than you realize. It's actually a really positive thing. And engaging with your employees and making sure you understand from them directly is a way you can measure how you're doing too. I really, really quickly also just wanted to say and echo the amazing comments from Francis that this is not about cancel culture for businesses. You are not a bad business if you had modern slavery risk. And there are certain businesses, because of the sector they operate in or the type of imports they rely on in the supply chains, that are going to have heightened risk. But it's probably a good thing for the New Zealand economy and for your customers that you're operating in that area. So don't feel that you're targeted or you're bad. And hopefully this is a way that can improve the way that you operate to be more resilient for your business. And so, Francis, you articulated that so well, and I just wanted to really emphasize that. And I think something to remember when you're doing this work, it's not about trying to cut modern slavery wherever you can, because the reality is it's incredibly difficult to overcome some of these issues. It's do no more harm, use your influence, and slowly push the dial. And it's a regime that should try and help us do that as businesses. Hence why these little pieces of wording, it's great we're engaging in them, and let's try and improve them where we need to and where we can. Sorry again for the distracting baby, but he's obviously very engaged and well in this dialogue.
Oh, thank you, Rebecca. That's the perfect note to finish on, and delighted that we had a cameo appearance from baby Walter. So ngā mihi nui to all our speakers today. It's been such an insightful session. On behalf of the Collaborative Advantage, a huge thank you to Professor Gail Pacheco, Rebecca Kingy, Nicola Swan, Kate Wilson-Butler, and Francis Blundell. Together, you have really helped us to understand why this modern slavery legislation is coming, what it entails, and how it connects to our the global context around human rights, as well as our human rights landscape in Aotearoa, New Zealand. At its core, this work is really about transparency and responsibility. It's about putting the right foundations in place rather than striving for perfection. Organisations that start early, are open about the risks and their gaps, and bring the right people together across legal, procurement, risk, HR and governance will be far better placed to really move beyond that compliance and make real progress over time. So thank you all for taking the time to join us today. The quality of this discussion has been incredible. Just a reminder that this is the first session of a two-part series. Today's focus was on why this legislation is coming, the components of the bill, and what good reporting looks like. The second workshop, which is next Tuesday on the 5th, we'll shift the focus to action, and we'll look at how to build a practical, fit-for-purpose modern slavery work program. So if you haven't registered yet, we do encourage you to do so. And just a reminder that the workshop fee allows for up to 3 people per organisation to join, just reflecting how important that cross-functional collaboration really is. Thank you again for being part of this collective effort. And I will close us now with a karakia. Kia whakaaria te tapu, kia wātea ai te ara, kia tūruki whakataha ai, kia tūruki whakataha ai. Haumie, hui e, tai ki e. Kia ora koutou.